present, I declare the motion passed. United Nations Sanctions Amendment Bill 2018.
政府議案
Government motions. The Chief Secretary for Administration will move his first and second proposed resolutions under the District Council Ordinance and the Small Claims Tribunal Ordinance respectively. Mr. James TO will move an amendment motion to amend the Chief Secretary for Administration's second motion. I've earlier informed members through the Electoral Secretariat that as the Chief Secretary's Administration's two motions relate to adjustments to the civil jurisdictional limits and were scrutinized by the same subcommittee, this Council will proceed to a joint debate on the two motions and Mr. James TO's amending motion, and then proceed to vote on the motions and amending motion one by one. The purpose of the motions and the amending motion and the debate and voting arrangements are set out in the appendix to the script. The joint debate now begins. I'll first call upon the Chief Secretary for Administration to speak on the two motions and move the first motion. Then I will call upon Mr. James TO to speak, but he may not move his amending motion at this stage. Members who wish to speak on the two motions and the amending motion will please press the Request to Speak button. I now call upon the Chief Secretary for Administration to speak and move the first motion. Chief Secretary for Administration. Mr. President, I move that the first motion under my name as printed on the agenda be passed to increase the civil jurisdictional limits of the District Court. I will also shortly be moving the second motion under my name as printed on the agenda be passed to increase the civil jurisdictional limit of the Small Claims Tribunal. In 2015-16, the judiciary conducted a review of the civil jurisdictional limits of District Council and Small Claims Tribunal, having analyzed the impact of increasing the limits on the workload of the court and the tribunal concerned, changes in economic indicators, and views of the stakeholders. The judiciary proposed increasing the general financial limits of the civil jurisdiction of the District Court from $1 million to $3 million. As regards the limit for proceedings involving recovery of land or relating to the title to an interest in land, the judiciary proposed increasing it from $240,000 to $320,000 in terms of the annual rent, rateable value, or annual value of the land. For the equity jurisdiction of the District Court, the judiciary proposed increasing the limit from $1 million to $3 million where the proceedings do not involve land, and from $3 million to $7 million where the proceedings involve land. Besides, the judiciary proposed increasing the civil jurisdictional limit of the Small Claims Tribunal from $50,000 to $75,000. The judiciary considered that the proposals above would allow better distribution of cases among the Court of First Instance, District Court, and Small Claims Tribunal. They would help ease the pressure of the increasing caseload of civil cases on the Court of First Instance and enable it to concentrate on handling cases of high claim amounts and greater complexity in nature. In addition, the proposals would also help lower legal costs, thereby enhancing access to justice for the public. The judiciary has consulted the Hong Kong Bar Association, the Law Society of Hong Kong, and a panel on administration of justice and legal services of the Legislative Council on the above proposals and obtained their general support. To cope with the increase in caseload at District Court and Small Claims Tribunal after adjustments of the civil jurisdictional limits, the judiciary, having carefully assessed the resource requirements, has made available additional court facilities at the court and the tribunal. The government has also provided the judiciary with the financial resources for meeting in full the manpower needs. In particular, the judiciary's proposal for the creation of new judge and judicial officer posts was approved by the Electoral Finance Committee in December last year. The judiciary will endeavour to ensure smooth operation of District Court and Small Claims Tribunal and continue to provide reliable services to court users after the adjustments of the jurisdictional limits. This proposed resolution, together with another resolution concerning the increase of the jurisdictional limit of the Small Claims Tribunal, have been scrutinized by the subcommittee on the proposed resolutions under the District Court Ordinance and the Small Claims Tribunal Ordinance. hereinafter subcommittee. The subcommittee held 2 meetings and supported the government for moving motions to seek LegCo's endorsement of the 2 resolutions. Mr. President, during the subcommittee's scrutiny of the proposed resolutions, LegCo passed the Statute Law Miscellaneous Provision Bill 2017, thereby enabling the civil jurisdictional limit of District Court for cost-only proceedings to be amended by way of resolution of LegCo as well. We therefore proposed and obtained the subcommittee's support to include the amendment to the jurisdictional limit of District Court for cost-only proceedings in the proposed resolution now placed before members for approval. I would like to take this opportunity to say that the amendment is now placed before members. I would like to thank Mr. Hon James TO, Chairman of the subcommittee, and other members of the subcommittee for their views and support of the proposed increase of the jurisdictional limits of District Court and the Small Claims Tribunal. Regarding Mr. James TO's motion to revise the jurisdictional limit of Small Claims Tribunal to $100,000, as we and the judiciary explained to the subcommittee during the scrutiny of the resolution, the current proposal of increasing the jurisdictional limit of Small Claims Tribunal to $75,000 was made after conducting a comprehensive and objective analysis taking into account a host of factors, including the need to enhance access to justice, the effect on demand for and operation of small claims tribunals services, changes in economic indicators, etc., as well as the views received during consultation. The proposal had also received general support from stakeholders including the Hong Kong Bar Association, the Law Society of Hong Kong, as well as the LegCo Panel on Administration of Justice and Legal Services. I wish to point out in particular that on the basis of the current proposal, the judiciary had secured additional financial and manpower resources and accommodation and arranged training for additional staff with a view to enabling Small Claims Tribunal to handle the impact arising from the jurisdictional rise. In particular, the proposal of creating additional judicial posts, which was approved by the LegCo Finance Committee in December last year, was also based on the revised jurisdictional limit of the Small Claims Tribunal of $75,000. Upon careful consideration, the judiciary considered it inappropriate to adjust the jurisdictional limit of the Small Claims Tribunal without going through detailed analysis and comprehensive consultation. Any changes would have an impact on the operation of the Small Claims Tribunal and therefore should only be implemented after going through a fresh round of detailed and objective analysis and comprehensive consultation. However, this would take time and would inevitably delay the implementation of the jurisdictional rise of Small Claims Tribunal and would not be conducive to the public in terms of enhancing access to justice through the Small Claims Tribunal, nor in the interest of the community as a whole. After considering the explanation of the government and the judiciary, the subcommittee supported the proposal of raising the jurisdictional limit of the Small Claims Tribunal to $75,000. I invite members to support this motion to increase the civil jurisdictional limits of District Court. Later on, I will move another motion to increase the civil jurisdictional limit of Small Claims Tribunal. I invite members to support the motion proposed by the government and vote down the amending motion proposed by Mr. James TO, with a view to implementing the increase of the jurisdictional limit of the Small Claims Tribunal from $50,000 to $75,000 as soon as possible. The judiciary is pledged to closely monitor the statistics on the caseload of the Small Claims Tribunal and the actual operational impact for 2 years upon the implementation of the new jurisdictional limit of the Small Claims Tribunal of $75,000 and conduct a review to see if there is a case for further raising the jurisdictional limit of the Small Claims Tribunal. Upon passage of the 2 motions, the judiciary will make consequential amendments to the Small Claims Tribunal Fees Rules Cap 338B and table them at LegCo for scrutiny separately. Subject to completion of the legislative process, the revised civil jurisdictional limits of DC and SCT, together with the consequential amendments, are expected to come into effect in the second half of 2018 on a date to be appointed by the Chief Justice. Thank you, Mr. President.
I now propose the question to you that the first motion moved by the Chief Secretary for Administration be passed. The Honourable James TO. Madam Deputy, I bumped into 2 residents this morning, one at breakfast. I was having noodles and the shop was open right after 7 o'clock. And the member of the public asked me, "Are you busy?" I said, "No. I would be seeking to raise the jurisdiction of the Small Claims Tribunal. Today, the administration is proposing to raise it to 75,000 after 19 years, and I said I would like to raise it to 100,000. And he said, "What? 100,000? Meaning that anything beyond that would go to the district court." He had parked his car nearby. I believe he might be a taxi driver or a driver of a private car. So this was the reaction of a member of the public. And then the second member of the public that I bumped into was such that I was meeting a member of the public this morning, and then in Causeway Bay I was in the lift, and I was telling this member of the public that this was what I would do today. And then they actually reacted in the same way. They said, "What? Even if it was raised to $100,000, you must understand that it is one way to do things if you quote a figure behind closed doors. But if you ask the public, you tell them, if it is $100,000, you would have to go to the district court." And they may say, "What? Really?" This is a very natural reaction. Mr. Secretary, if you are realistic, if the judiciary is realistic, you should understand that this has not been changed for 19 years. It was back in 1999 and it was set at $50,000. Now 19 years have passed. And you may say, "I'm raising it by 50%. But you have to look at the absolute value and look at the social disputes and minor claims proceedings. If you compel people to go to the district court, would people still take forward such proceedings?" Madam Deputy, let me give you some pragmatic examples. In recent years, I handled the aborted building projects in the UK. Local agents would enter into agreements with buyers, and these are compensation agreements, totally $80,000, but the agent did not make good the compensation. And if it's $80,000 and you have to go to the district court, well, the tail would be wagging the dog, so to speak. And the average citizen may feel this can be handled at the SCT, even if it is a non-refined kind of justice, and people would say it's okay, we can handle it at the SCT. But if you tell them, starting from 1999, it has been 19 years, and you now increase it by 50%. Just now, the CS4A said the judiciary and the administration have looked into different things like purchasing power, etc. But frankly, if a dispute involves just less than $100,000, well, there are many of these nowadays. Recently, I was also handling refurbishment or owners incorporated cases, and these amounts are quite common. Even if you ask me why I want to increase it to $100,000, I would just say, well, it is not science-based. Let me try to be scientific with you. Say from 88 to 99, inflation was 100%, and the administration raised the jurisdictional limit by 230%. That is from 1988 to 1999. You increase it to $50,000. You said that you consider the actual assessment of people's purchasing power and Hong Kong's economic growth. And now in May 1999, and now we're in May 2018, and the cumulation would be 30 to 35%. And this is 2.53 times that of the period between 1988 to 1999, and I believe you should increase it by at least 70 to 80%, meaning 85,000 to 90,000 instead of 75,000. Madam Deputy, members of the public may be seeking less than $100,000. I'm not talking about 30,000 to 40,000, but anything under 100,000. Well, if a legal dispute involves that kind of amount and people have to go to the district court, well, if none or no parties go for legal representation, it's all right. But if the other party engages a legal representative, then justice cannot be done. Why? Because if you think that there is a case, a chance for you to lose the case, the legal fees would be more than the amount sought after. You can say that this would be a barrier to the public's access to justice, or you can say that justice is deleted. And of course, you say you can go for legal aid. If it is $90,000, you can go to the district court and you can seek legal aid. We all know, and the CS4A will know because he oversees the policy for legal aid. There is the legal aid ordinance. Again, the tail would be wagging the dog. If I provide you with a legal representative under legal aid, the legal fees will not be commensurate with the compensation you are seeking, because I would be spending hundreds of thousands of public money for you to get compensation just to the tune of $90,000, and so the legal aid application will not be approved. Even if there will be a prima facie case of winning the case, but still you are only seeking $90,000 in compensation. So the door to legal aid is also closed. So there will be no legal aid. And the administration said, if I increase it from 75,000 to 100,000, would it affect the workload of the SCT too much? It will be flooded with cases. Number one, we asked the administration, can you give us cases between 75,000 to 100,000 that were heard at the district court? This is not the only indicator, but one of the indicators. We asked the administration for the caseload, but it was a very small figure. The judiciary said that from 2013 to 2016, the compensation amount was 50,000 and above, meaning that the amount was over 50,000, but they only sought 50,000, and it took up only 12% of the total caseload. And in 2015, there was a downward trend. In 2017, it went down to 9.6%, meaning many of them were getting less than 50,000. That is a very small proportion compared to other compensation claims. I therefore have reason to think that there would not be a big impact even if we raise the jurisdictional limit to $100,000. And up to the 31st of March 2018, and if we look at the government revenue account, the SCT from application to the first hearing, the average time taken was 35 days in 2015 and 34 days in 2016. The judiciary set the target at 60 days for average waiting, but this was just over half of that period. In other words, the SCT still has capacity to deal with more cases, even if the compensation limit is raised to $100,000. Plus, in recent years, there are more presiding officers and investigation officers at the SCT in recent years. Also, the administration said, look, we have consulted the stakeholders. Please do not come up with an amendment out of the blue. Sorry, this is not fair. Because when the administration made this proposal, first it went to the AJLS panel, where many members already said that $75 was not good enough, and we asked the administration to raise it. If the administration had listened to members carefully, and many of those were from the pro-establishment camp, you should have gone back to the judiciary and also you should have taken it up again with the stakeholders instead of just saying we have thought of $75,000 and we are just informing you at LegCo. If you want to ask for an increase, wait till next time. This is the attitude of the administration. The administration says, I am the administration and I call the shots. But look, if you tell people you are going to introduce an increase, who would say no? But here we make the legislation. We represent the public. And the LegCo is telling you it is not good enough. And you should take it back and renegotiate. And some members proposed 100,000. You should have gone back and asked. But you didn't do so. You thought that the AJLS panel could be brushed aside. This is the attitude of the administration. The public, please listen. At the AJLS panel, members raised different opinions. But after that, the administration just went ahead with 75,000 and then he said, that's it. We have asked people. It's just that we have not asked the legislators. And then when the legislators asked for an increase, it said, no, wait till next time. Remember, this time you tell members that we should wait till next time. You are not just telling me. You are telling the public. You are telling the tens of thousands of cases. To be plain, cases involving 75,000 to 100,000 or just above 100,000, you are just suppressing them to the level of 75,000 and people would not be able to seek just compensation. This is the worst. You are giving rise to a lot of disputes amongst people. If they go to the court, at least there will be a judge making the adjudication and people would accept it. Well, some people would still be aggrieved, but after the procedure, they would accept judicial justice. But now you artificially remove certain cases from the system. The administration said it has done a review. It has asked all stakeholders. That is not an answer. Look at the process. You should have gone back and renegotiate. Okay, another one. The administration said, look, we have listened to you. And then they would always say, they would be the dominant view, and you should act as a rubber stamp. You must chop on our amendment. Any other amendments would be a barrier. And if you have further views, wait till next time. And then the administration said, 2 years later, there would be a review. The thing is, it's really strange. At the committee, and many other members and myself put forward opinions. Well, they made the oral remarks, but then when they vote today, you will see what they will do. At that time, the administration felt that it had to reply because there was pressure. And so they were trying to convince certain members. And then they said, okay, we have heard you. We have really heard you this time. So many members asked for an enhancement. The last time we waited 19 years. But this time we are going to give you face. We have listened to you. We will do a review in another 2 years. And now you tell me, okay, there will be a review after 2 years. But then at the time of the review, you could say, we had already increased it from 50,000 to 70,000. And what is the inflation rate over a period of 2 years? And even if it is 3-4% or 8%, should I go up to 80,000 odd? It is neither here nor there. This kind of trick, this kind of logic, this kind of procedure, does that show any sincerity on your part? The administration should enhance it by a wide margin. If you ask me, $100,000 is too small, I'm just rounding up the figure to 100,000. And if you still say it is going to make a big impact, there will not be enough judges, nobody is going to believe in you.
Mr. Hon Chao. Madam Deputy, I hereby submit a report as Chairman of the Subcommittee on Proposed Resolutions under the District Court Ordinance and the Small Claims Tribunal Ordinance. The Subcommittee held 2 meetings with the administration to deliberate on the 2 proposed resolutions. The Subcommittee would not move amendments on the 2 proposed resolutions. Over the course of deliberation, the Subcommittee realized that since the Statute Law Miscellaneous Provision Bill 2017 was passed on the 11th of April, the judiciary proposed to include the amendment to the District Court's jurisdictional limit for costs-only proceedings in the proposed resolution under the District Council Ordinance. The Subcommittee raises no objection to the amendment. Moreover, the Subcommittee had detailed discussions on the proposed jurisdictional limit of the SCT. Some members felt that the proposed increase in the SCT's jurisdictional limit from $50,000 to $75,000 is minimal, and they proposed raising the jurisdictional limit from $50,000 to $100,000 to ensure that the SCT can handle more cases with lower claim amounts to further enhance access to justice. The judiciary explained that adjusting the SCT's proposed jurisdictional limit at this stage would require a restart of the relevant preparatory work, including public consultation. This would inevitably delay the implementation of jurisdictional rights, and it's not in the interest of the community. To address members' concerns, the judiciary has undertaken to implement the proposed $75,000 limit for SCT and will closely monitor the caseload of the SCT in 2 years, in the next 2 years, as well as the actual operational impacts on SCT due to the $75,000 proposed limit, and it will review whether there's a need to further adjust the SCT limit, including whether or not there's a need to set the limit at $100,000. Having considered the judiciary's explanation, the SC agreed with the starting point of $75,000 for the proposed limit, but the government must report to members the results of the review. The SC also feels that the last review on the jurisdictional limits for DC and SCT was 15 years ago and was too long. The SC also requests the government to make future reviews more regular, and here are my views on the proposed resolution. I was a new member to LegCo, and after coming on board, I wanted to raise the SCT jurisdictional limit, and this is a matter of high importance to me. On the 18th of October 2016, at the AJLS panel, I propose a rise of SCT jurisdictional limit from $50,000, and in 2017, I made an oral question at the Legislative Council suggesting a raise or a rise of the jurisdictional limit from $50,000 to $100,000, and subsequently at the AJLS panel, a detailed discussion was arranged. Recently, the government introduced the proposed resolutions to LegCo, and I was glad to be able to chair the subcommittee, and I took part in the deliberation of the proposed resolutions. For the proposed rise of SCT jurisdictional limit from $50,000 to $100,000, I was one of the first members to propose such change, and I'm sure some other members would feel the same. Over the course of deliberation, there were certain points I want to share. In the past, we sought to increase the limit from $50,000 $100,000 because, as you know, on the district level, we take up a number of legal consultation cases, and no counsel can be employed, and the risk of counsel fees could be avoided. For a lot of legal practitioners, they might charge $80,000 to $100,000, but the claims would just be $20,000 to $30,000, which would not make sense. And this would sometimes prejudice access to justice for the public, and the SCT would be able to overcome this problem. For some claims, the claim amounts might be $60,000 or $70,000. When they come to me for advice, they understand that SCT can only handle claims under $50,000. They would often forego the excess $10,000 or $20,000, so they would limit their claims to under $50,000 so that the case can be handled at the SCT. Of course, this is something they can choose, but as we all know, they are foregoing part of their claim value, and this is why we must raise the jurisdictional limit of the SCT. As for the proposal to raise the limit from $50,000 to $100,000, over the course of deliberation at the subcommittee, we put a lot of questions to the government, and the judiciary also sent representatives. At the time, a lot of members asked the same question. If the limit is raised to $100,000, would that be possible? I can say that the judiciary is the responsible agency in this exercise, because at the end of the day, the judiciary must accept the proposal and implement it. And at the subcommittee, the judiciary made it clear that they have doubts in terms of operation, because if the limit is raised to $100,000, the judiciary might not have the manpower and resources. And secondly, when taking views from the public and members, there must be a process in enhancing the functions of SCT. Let's say there would be 10 steps, and ultimately they came up with the proposal to LegCo. Some people might find the judiciary at fault because they refuse to accept the proposal, but from an objective point of view, if the judiciary raises doubts on their own operation, and if they propose $75,000 after going through a string of steps, well, at the subcommittee, we also raised this question. If we do not accept the proposed limit of $75,000 from the government, and if, like what Mr. James TO said, we want to raise the limit to $100,000, then the judiciary would not find it feasible. So they have no choice but to withdraw the proposed increase in limit and the enhancement of SCT function. So having gone through a long process, of course, you know that I have waited a long time for the jurisdictional limit or jurisdictional rise and enhancement of the SCT's function. I would not say that this would help everyone, but at least we can help some in overcoming their problems. So if we go back to square one, how many years would we have to wait, or would the judiciary have to wait? before they can address everyone's needs. The two legal professional bodies express their views on the issue. They support the $75,000 limit as a starting point, according to the judiciary and administration. And the subcommittee also requested the judiciary to address our views. The $50,000 limit has not been reviewed for a very long time, and $75,000 should only be a starting point but not the end. During the deliberation of the resolutions, the judiciary made a commitment of conducting a review every 2 years. If there would be a review after 2 years, $100,000 would be the bare minimum. 2 years later, after a review, the limit should be even higher than $100,000. It might be $120,000, $130,000, or even $150,000, but $100,000 would be the bare minimum. I have received cases recently some people are aware of the enhancement of functions of the SCT, and some people asked me when this would be implemented. And if the resolutions are accepted, they could be implemented by the second half of 2018 at the earliest, or after the summer recess. Lawyers would understand that for a lot of cases there are time limits. For example, certain negligence cases have a time limit of 3 years, or personal injury claims. If the changes are implemented soon, for claimants that are in a case, they would have to pay counsel fees if the case is taken to the district court. But with the jurisdictional rights, some claimants could use the SCT if the claims do not surpass the limits. Madam Deputy, if we are to veto the proposed $75,000 limit and instead propose $100,000, the judiciary would withdraw the proposal altogether, and we will have no idea when this exercise can be restarted. We have spent a very long time for this jurisdictional rise to $75,000. Of course, both James TO and myself feel that a $100,000 jurisdictional limit can help a lot of people. So these are our wishes. But as chairman of the subcommittee, I must consider a very real issue. If we veto the proposed $75,000 limit in lieu of $100,000, the result would be that the function of the SCT cannot be enhanced, and we will have no idea when this can be restarted. A more responsible approach would be to approve this today, and the new limit can be implemented in the second half of this year, and there will be another review within 2 years to further raise the limit. Thank you.
Mr. Leung Yiu-chung.
根據小額錢債審裁處嘅條例咧，動議呢個決議案。
Well, the resolution proposed under the DC Ordinance and SCT Ordinance seeks to increase the jurisdictional limit of Small Claims Tribunal to $50,000 to $75,000, and the government has undertaken to review the statistics of the caseload at the SCT in 2 years' time to gauge the impact and see whether the civil jurisdictional limit should be further raised. On this issue, Madam Deputy, just now I carefully listened to Mr. Hon Chow's speech. In the beginning, I was delighted because he said that ever since he's joined this council, he has hoped that the jurisdictional limit can be further raised to $100,000, and the higher the better. But to give a start, it should be $100,000. But then I felt disappointed as he continued with his speech, because he is kowtowing to reality. Because if we do not agree with the proposed $75,000 jurisdictional limit, then the concern is that resources and manpower will not be able to cope with the increased limit, and it would be pointless to further raise the limit. And if we do not support the $75,000 limit, the judiciary would need to start this work afresh, and it will take at least 1 or 2 years. So that for potential claims ranging from $50,000 to $75,000, they won't stand to benefit from the proposal, and these victims will be disappointed. So we should support the government's resolution and wait for 2 years before we have the analysis and see whether we should further increase the limit. And even Mr. Hon Chow just now said it would be best if we could raise it to $150,000. But very often this is what happens in this council. Well, every time the government makes a proposal, there would be an increase, an improvement on the existing mechanism. Please pause, Mr. Leung Yuk-chung. Yes, Mr. James To, would you like to return to your seat? Is that your seat? Point of order. I'd like Mr. Leung to clarify. Increasing the amount to $100,000, the government will withdraw the proposal, or the government will refuse to move this resolution. Well, in the subcommittee's report and from the CS4A's speech, I haven't heard anything like that, because if Mr. Leung Yuk-chung is quoting from Mr. Hon Chow, I think it's for Mr. Hon Chow to clarify that this never happened. I think your point is clear. Mr. Leung Yuk-chung, you can clarify whether this is the case. I thank Mr. James To for the point of elucidation. I was really paying attention to Mr. Hon Chow's speech, and I was quoting from Mr. Hon Chow. And if Mr. Chow seeks to clarify the position later on, please do so, because I am going to question this anyway. Does it mean that if we veto the $75,000 increase, and if we vote in favor of Mr. James To's proposed $100,000, what will happen? I don't know what will be the next step of the administration, because years ago, in relation to the long service payment, because of a member's blockage, the government withdrew the resolution. So that happened before. I don't know whether this will happen again this time. But it all boils down to our principle. If Mr. Hon Chow also agrees that $100,000 would be appropriate, then although the government may question the manpower and resource implications, and that it's not feasible, I think it's absurd. If the resolution is passed by this council, no matter how difficult the administration should go ahead with it, the administration cannot tell us that they lack resources and manpower, and that it should be set aside for the time being. Because this is unprecedented, I don't think this will happen. I therefore disagree with Mr. Hon Chow's point. Second point, the exercise will need to be to start afresh, and it will take a long time. I don't believe that. Just like the reinstatement order, Mr. Matthew Cheung, the CS4A, should be very clear about that. The matter was taken back to the LAB for discussion for another year. This is still fresh in my mind, but I think that we need to find out who should be responsible. Mr. Hon Chao, it was 1999 when the amount was raised from $15,000 to $50,000, and it's been 20 years. Since we have another exercise to increase the limit by $25,000, who should be responsible? Of course, the government. The government is playing deaf and turning a blind eye to the problem with the unreasonable civil jurisdictional limits of the SCT. And now it will only be increased by $25,000. It has been unreasonable for so many years. The government is totally out of touch with reality. The government doesn't understand public sentiment, and we should not condone the government's attitude. The government should be responsible. They should not put up an excuse that because of manpower implications, the limit should only be increased to $75,000, because it is absurd. You sound so firm in saying that many victims suffer losses, but for members who have taken up such cases, especially members representing the labor sector, would understand. Many victims made compromises. They would like to file a claim of $100,000, but in the end, because of the mechanism, they are unable to pay for the cost of the district court, and they therefore, as a compromise, filed a claim with the SCT. But the point about the system is for the public, especially the grassroots, to get reasonable compensation, to seek justice. But now you are succumbing to the administration, which is totally ignoring social changes. It's been 20 years. You know, for the cumulative inflation rate, it far exceeds that increase. And for the government to talk about a lot of work being done by the judiciary, it is nothing but a joke. Have they really conducted any survey before proposing such a very minor increase? I am very disappointed, because for the Small Claims Tribunal, the only advantage they enjoy is that neither parties can be legally represented, so that individuals can have a level playing field in putting forward their claim. And that's the basis of the system. Over the years, however, the government has been turning a blind eye to the issue. On the contrary, the government is condoning such practices. Well, Mr. Hon Chao, you also mentioned that a review will be conducted in 2 years. Why 2 years? Why would you think it takes 2 years? Well, let's say I trust the government and that a review will be conducted in 2 years. Then ultimately the limit will be raised anyway. So it's a question of whether they are willing to do it. Well, if Mr. James TO's amendment is passed, I really don't see how the government will be blatant enough to say that they cannot do it, even if this is passed. I don't think they can say that. If this is an accountable government, which really give public any fairness in pursuing claims, the government should not adopt this attitude. So I think the pro-establishment camp should take this opportunity. On behalf of Mr. James TO, I urge members to support his amendment, so that those who would like to pursue justice will not wear a straitjacket because of the jurisdictional limit. Well, Mr. President, I would like to share with you some cases I came across. These are real tragedies. Well, very often, in terms of financial disputes, several $10,000 may be involved, and this may fall outside the remit of a labor tribunal, and the victims would therefore need to pursue the claim with the Small Claims Tribunal. At the moment, we know that wages have increased, and very often the limit of 50,000, even 75,000 would be exceeded. So what happens is that they're not able to get back their hard-earned money, and it is unfair. It's really regrettable. Over a decade or so, the government has done nothing, and the government can only propose such a minor increase. It's really disappointing. Mr. President, I am not a member of the panel or the Bills Committee. I don't understand the plight of or the difficulty of the government, but I still think that even if there is difficulty, it should be resolved by the government, not by us. That is, if the government is determined. Well, not to mention that we are sitting on abundant resources. You could always hire more manpower and increase your facilities. Don't use these two reasons as the excuse to say that there is no support for increasing the jurisdictional limit beyond $75,000. Mr. Hon James TO continued to say that we should wait for the next review, and then we can start with 75 or $100,000 as the starting point, not the ending point, so as to push the government to do more. Anyhow, Mr. President, if there is a delay, I don't think it's fair to anybody, because otherwise they will not be able to pursue the claim rightfully. I think this is as of right that we should attach importance to. These claimants have the right to file a claim, and they should not be deprived of the right.
係有做一啲小額錢債案件嘅上訴嘅案。
Mr. Spock, I have been dealing with SCT claims, and with regards to this exercise, we are looking at the jurisdictional rise for the SCT jurisdictional limits. However, we must also look at the DC jurisdictional limit, because any adjustment would benefit civil cases in Hong Kong. All along, the legal profession has always complained about the low DC jurisdictional limit. For cases of more than $1 million, they have to be taken to the High Court. And this would lead to problems with costs or litigation costs, because the costs of the high courts would be higher than those of the district court. For more complicated cases, there won't be a judgment till a few years later, and the high court judges have a very heavy workload. Of course, I know some judicial officers from my role as a legal profession representative at LegCo. They told me that many high court judges have to work 7 days. They might even have to use their holidays to write their judgments, which is not ideal. But as the DOJ knows, the waiting time is also unsatisfactory, and the judiciary fails to meet their own standards or schedules. Unfortunately, the situation has not improved. It has actually gone worse. There are 7 current vacancies for judges at the High Court, and this seriously affects the handling and efficiency of cases. So raising the DC jurisdictional limit from 1 million to 3 is necessary. And I am happy to see the proposed resolutions, and hopefully they can be passed. District councils do not have enough judges. When you raise the jurisdictional limit from 1 million to 3 million, would you concurrently hire more district court judges, especially for civil cases? And this is certainly necessary. In the past, the recruitment of judges lies mainly with barristers, but in recent years, we have said that we should hire more solicitors with experience in civil cases as judges, and we certainly have a lot of talents. Overseas recruitment is also a good option in filling the vacancies at the judiciary. The main controversy today is not on the DC jurisdictional limit, but the SCT jurisdictional limit. I have thought long and hard on the issue, and I agree with Mr. James TO and Mr. Leung Yiu Chung because they are very pragmatic, while the judiciary and administration are out of touch with reality. The jurisdictional rise from $50,000 to $75,000 is certainly minimal. The rise should be even greater. I also looked into the operation of the SCT. We must not ignore the issues faced by the judiciary at the moment. There are 36 current vacancies at the SCT, and so the number of vacancies have gone up from 26 to 34 at the SCT. Of course, you might say that they should hire more people. The judiciary has the resources, but very often they fail to recruit enough. If you ask a successful counsel or barrister to enter the judiciary and begin as a magistrate, they have to pay a very high cost, including a very low starting salary, and they must be very committed to serving the public. Of course, salaries would go up. For SCT, DC, and HC judges, they would enjoy pay rises down the years, but still, they can never catch up with the income earned in private practice. So I'm just trying to understand the situation of the judiciary. They have tried very hard to recruit judges at all levels, but the situation has not improved. For the number of magistrates, there are 36 vacancies at the SCT. I believe the judiciary wants to raise the SCT limit, and they know that even $75,000 is not enough. I have dealt with appeals for some SCT cases. Even though the amounts were low, the complexity of the cases is often not low. For SCT cases, the amounts involved might be low, but the complexity would not be lesser than other cases. So who would hear these cases? So very often the deputy magistrates, which are relatively inexperienced, would hear these cases. We are talking about 20 or 30 somethings who are committed and would like to serve the judiciary, but very often they are inexperienced because indeed they are young solicitors and barristers. When they join the judiciary, they might have 10 years or less of experience as a solicitor or barrister. Of course, they are very committed and they really want to serve in the judiciary. However, their case handling ability is relatively inferior and they are relatively inexperienced. If you ask them to handle SCT cases, the amounts might be small, but the cases could still be complicated. As I said, small claims do not equate to less complicated cases. Very often, the litigants are unrepresented, and the claimants are often unrepresented. And in these cases, judges have to spend at least half the time to deal with them. When you look at high court cases, about 1/3 of the civil cases are unrepresented, and even if only one side is unrepresented, the judges would have to spend at least 50% more time. So very often these SCT cases are challenging and the caseload is also heavy. And with the shortage of staff at the judiciary, I would understand why the judiciary would be concerned if the limit is further raised to $100,000 from $75,000, because the magistrates would not be able to deal with the caseload, and there would be a larger and larger backlog. So for young magistrates, with a high caseload, the quality of their judgments might be affected. This is only natural. It's not that they are subpar or inexperienced, but with so many cases, the likelihood of making errors would increase. And it would be more likely that one of the parties might not be convinced that they are given justice, and they might lodge appeals, and we will also see more appeals. And for appeals, they would be taken to the High Court, and if the High Court itself has 7 vacancies, and with more and more appeals, this is something the judiciary must face up to. So from their perspective, the situation is not ideal. But I do not agree with the judiciary and administration that $75,000 is enough, and it's too late to review the matter only after 2 years. But I do sympathize with the challenges of the judiciary, and I'm trying to explain the challenges faced by the judiciary. Hiring judges is very different from hiring staff in other departments. You can only just offer higher salaries if you want to successfully recruit. The hiring of judges is not just about money. If someone decides to become a judge just because of money, he would not make a good judge. Of course, judges would expect reasonable return, but they must be committed to facilitating justice. If they join the judiciary just because of money, then they would be attracting the wrong people. That's why I understand the long-standing vacancies at the judiciary. The administration and judiciary are exploring raising the retirement age from 65 to 70 or 70 to 75 for judicial officers. Of course, this would help because some people might join the judiciary late in their early or mid-50s. They would still have 10 or 15 years to serve. Of course, this would be a solution, but this would only apply to judges at a high court or above level. For magistrates and lower judges, they still retire at 60. So again, will there be enough committed people joining the magistracies as magistrates in their 30s and 40s? This would be challenging because they must be extremely committed. So this is the problem we are looking at. I agree with Mr. James TO and Mr. Leung Yiu-chung. And I understand why the public feels that the limit of 75,000 is too low. But I urge everyone to be patient and assess the operation of the SCT in the next year or two, and we will see if the judiciary can successfully recruit more judges. I urge the government to offer the judiciary enough resources and support to overcome the manpower shortage, because 2 years later, members would no longer be so patient. With a review 2 years down the road, you should be able to fill those 30-odd vacancies. If you fail to recruit magistrates, the judiciary should review why they are unable to recruit quality magistrates. Thank you.
主席。
Mr. Junius Ho, President, the CS4A is proposing to enhance the jurisdictional limit at SCT from 50,000 to 75,000. I support it. And also the enhancing of jurisdictional limit of DC from 1 million to 3 million. Again, I support that. President, I have heard Mr. James TO and Mr. Dennis Kwok saying that first we should enhance the SCT limit to 100,000. I understand the rationale, but we must act with caution, especially for SCT. 100,000 is not a small amount for the average member of the public. If we enhance it from 50,000 to 75,000, we can accept the risk because there is no legal representation at SCT. Litigants have to rely on themselves, their own performance and submissions. And in handling evidence or jurisdictional matters, these litigants are not experts. The SCT doesn't want to become too technical. That is why the presiding officer would sit and look at the justifications and rationale from both parties, and in order to adopt a brisk and brief process in order to tackle cases. I believe 75,000 would be able to reflect the risk which is commensurate at SCT. But if we enhance it to 100,000, the stakes would be too high for the parties. Anything above 75,000 should still go to the district court. I think that is appropriate. It seems there are no other opposing views, but I heard Mr. Dennis Kwok talk about the biggest problem of the judiciary and whether there should be a reform, especially in the area of human resources. I clicked onto the website of the judiciary, and I found that in Hong Kong, given 185 judges ranging from CFA to the appeal court to the CFI to district courts to the magistrates' courts and other tribunals, including the SCT and the coroner's court. Altogether, there is just an establishment of 185 judges and judicial officers. But every year we handle over 500,000 cases. Hong Kong is such a small place, and with such a small judicial team, they are serving Hong Kong people. And we are talking about maintaining the spirit of the rule of law, and I believe the team has done an excellent job. In recent years, apart from economic and civil litigation, they are also drawn into political swirls, and I can understand their difficulty. What we should look at now is whether to expand the judicial team. Mr. Dennis Kwok said it is not that it doesn't want to. The establishment of 185 is not even filled. Sometimes there are succession gaps when judges retire. And this has caused bigger workload and backlogging of cases. And very often, the remuneration for judges is such that it is keeping barristers away. If I practice in private, I can make 200,000 to 300,000 every week. But if I become a judge, I only earn more than $100,000 a month. So they cannot compare with each other. And there is another barrier keeping people out of the judiciary. This is a very old rule, and we must review it. Once you join the judiciary, you are stuck. Once you are in the system, you cannot practice as a lawyer, even when you leave it. Especially for young lawyers who may be interested in becoming a judge. But if they really become a judge and then only to find that you don't want to stay there, you cannot practice, even if you choose to leave. I think there must be a review in this regard. The only thing retired judges can do is to become a mediator. It is actually a kind of civil action. It is not going to be a court, but the arbitrator acts more or less like a judge. And if they don't become arbitrators, can they represent a particular party? Yes, at arbitration. If we are marching towards a new approach, then why should we still bind our own hands? These very old rules are keeping upcoming young people in practice from joining the system. Today, we should only be talking about raising the jurisdictional limit for SCT from 50,000 to 75,000. I think it is appropriate and also very prudent. But at the same time, we must try to see how we can clear the backlog of cases and the inadequacy of human resources. We should think deeper into this and try to find a way out. I speak in support of the CS4A's resolution, but I'd like to bring up those 2 points where the administration should play a leading role and review the very archaic rules so that we can optimize the system. We should not be complacent about the present situation. Don't be too inert in facing the present situation. We have an establishment of 185 judges, but we are treating or tackling 500,000 cases every year. I think we should go into the Guinness record for this.
Mr. O'Loughlin. Mr. President, I speak in support of Mr. James TO's amendment to increase the current civil jurisdictional limit of the Small Claims Tribunal. That is the cap on how much a claimant could claim, from $50,000 to $100,000. Well, the government's proposal is $75,000. Should we increase? Should we support this increase? I would say that any increase is better than staying put at $50,000. Imagine, last time, which was 1999, we increased the limit to $50,000, but we're in 2018 already. And if the limit is still not adjusted, I would say that it is lagging far behind the economic indicators. But why is it that an increase to $100,000 would be more reasonable than just $75,000? First of all, we need to ask why we would go to the Small Claims Tribunal. Simply put, parties can appear in person in front of the Small Claims Tribunal to resolve monetary disputes. The disputes may or may not be complex, legally speaking. For example, there may be a debt owed in the sum of several $10,000, and if I want to sort it out in court, then I could go to the Small Claims Tribunal. In short, however, we need to bear this risk as users of the Small Claims Tribunal because we're not represented, we don't have the means, and if we had, we would have gone to filing a claim with the District Court. So, if we do not have the means to engage a legal counsel to take the case to District Court, then at least we should have some confidence in the pursuance of our claims at the Small Claims Tribunal. So, can we really address these cases by increasing the limit to $75,000? I don't doubt that some cases involve only a claim of several thousand or $10,000. Indeed, the existing mechanism could address these cases. But for the cases I came across, the claim amount exceeds $50,000. For example, payment in arrears in relation to renovation works. They come in different details. say, installation of a cable, and the amount involved will not be over $50,000. But in some cases, the whole flat may be redecorated such that the amount could reach $70,000 or $80,000. Now, if the decoration company is shoddy in its work, or that payment is not made in arrears, then how should the public pursue the debt? At the moment, at the Small Claims Tribunal, the amount of claim is capped at $50,000. Right. Even with the increase to $75,000, you can at most claim $75,000. I would say that if the cap is higher, it would allow the claims of a higher amount to be pursued. That is why, if Mr. James TO's amendment is passed, we will be able to allow cases involving higher amounts to go to the Small Claims Tribunal. I also came across another case in which an online shopping website folded, and I helped a user to pursue a claim exceeding $50,000 with Be Crazy. It happened in around 2015-16. Now that was an online shopping platform. Commission was charged by the website operator. When the website folded, many sellers already sold their goods, but the payments were not made by the website operator. And then the money was drained away with the folding up of the website. For these sellers, they thought that the transactions had been completed, and yet they got nothing in return. So they turned to the Small Claims Tribunal to file a claim. Usually, the amount involved might just be $10,000 or $20,000. But in a case, I'd like to quote this case, a Miss Chen purchased a piece of furniture, and through this platform, a check was made out to the seller. The company folded up in October, and 5 months lapsed. Payment had not been made. As a result, $200,000 were owed. And like Mr. James TO said, Mr. President, you might say that $200,000 would exceed the proposed $100,000 limit of James TO's amendment. In the end, the user could only claim for $50,000. That's really a far distance away from $200,000. You might say, if you have the means, you can take the matter to District Court and engage a lawyer. But then there are risks involved. You may lose the case, and then you need to pay the cost for the other side. Not to mention lawyers' fees, usually some $20,000, $30,000. So one would need to assess whether it is worthwhile to file a claim at the district court level just to pursue a loss of some $100,000. Because in the end, you don't know how much you would pocket. But we have Small Claims Tribunal to deal with claims not involving huge sums of money, and then by way of summary proceedings, we'll be able to deal with all these matters. In the case of an online shopping platform, because the company had been declared bankrupt, there would be no respondent in these cases. And the users needed to act quickly, because after declaring the bankruptcy order, these users would need to get an award from the tribunal so as to pursue the claim with the company, and justice could only be sought with the Small Claims Tribunal. Unfortunately, the amount is capped at $50,000. There are still many members of the public not being able to get the compensation in full because of the cap and because of the legal fees involved. Although the actual amount of claim could exceed $75, because of the constraints I mentioned, they would not file a claim in the end. And about Mr. James TO's amendment, I think we need to consider the justification. In 1999, the limit was increased by 230% from 15 to 50,000. At this exercise, however, the increase only amounted to some 50%. I don't know whether there is room to further increase the limit. Mr. Dennis Kwok just now in his speech referred to the difficulties facing the legal sector if the limit is further increased. For example, the number of vacancies would increase from some 20 to 30. And not many legal practitioners would want to become a judge or a judicial officer. But I don't think this is in conflict with Mr. Dennis Kwok's point. In fact, we'll be able to allow more legal practitioners to join by, for example, providing other forms of incentive, financial incentive, or extending the retirement age, so that more legal practitioners would be attracted to join the profession. And of the average waiting time, at the moment it's 34, so there is room to further increase the civil jurisdictional limit to make justice more accessible, because the performance pledge laid down by the judiciary is 60 days waiting time. At the moment, there may be manpower issues with the judiciary. But what happens if we conduct a review and find the situation to be similar 2 years later? Does it mean that this is at most a cap we can impose and the limit cannot be further increased? I think we need to consider and assess whether indeed there is no more room to absorb more cases for the Small Claims Tribunal. Mr. President, I have this strong feeling after dealing with cases involving online shopping platform. The government and the Legislative Council always talk about innovation technology. We talk about better support for the development of innovation technology. And legal system is one pillar of support. Let's say if we have IT business startups, which in the end folds, and if we do not have an avenue for users to pursue losses, how do we give confidence for investors to do business here in Hong Kong? Mr. President, I recalled back then when I followed up on these issues in the retail industry and wholesale industry, I have this strong feeling, and I understand that after seeing Mr. James TO's amendment, I need to take this occasion to speak so that be it the online shopping platform or financial disputes between individual residents over, say, renovation projects, the jurisdictional limit should be increased so that they can make use of the Small Claims Tribunal as a platform to access justice.
即係何君堯議員講，未必需要好擔心。
Well, let me reassure Dr. Junius Ho, because he questions whether there will be a greater risk because of the increased limit. I think we need to consider the reality. When I give evidence at the Small Claims Tribunal to convince the adjudicator to give a reasonable award to me, we need to follow very stringently the rules of evidence. And I cannot just, the adjudicator cannot just satisfy the whatever amount you're claiming. We need to consider the evidence and strike a balance before giving an award. So I am speaking to urge members to support Mr. James To's amendment. I so submit.
主席，我本人就冇。
Mr. Felix Chung. President, I was not part of the Bills Committee, but I would like to share some of my views. And at the Bills Committee, the administration and judiciary said that they would try to introduce more manpower in 2 years. And they would conduct a review later. For judges with SCT experience, there has been a backlog of cases, and there are statistics on the cases with different claim amounts. I am a member of the Bills Committee on the Inland Revenue No. 3 bill, which is the super tax deduction for innovation and technology. The Commissioner for Innovation took in questions from us, and the Commissioner accepted our proposals immediately, and she offered a 3-month grace period. We felt that 3 months is not enough, and we asked for 6 months. The Commissioner accepted right away. She was concerned that with the new super tax deduction, they would need a lot more manpower, and even the Inland Revenue Department would need a lot more manpower. But they still accepted our proposal, despite the fact that they had no experience in the past. We do not know how many organizations would apply for the super tax deduction, but they still adopted a 6-month grace period as members requested. And I also took part in the scrutiny of the Inland Revenue No. 6 bill, which is about transfer pricing. And it was in line with the OECD's requirements. Well, what I'm saying now is relevant to this bill. The government said our threshold is $100 million in assets, and organizations must make a declaration if they pass the threshold. Eventually, the government agreed with a $400 million threshold, which comprises of $300 million in assets and $100 million in revenue. But for this exercise, you should be able to anticipate the manpower level required for SCT cases. But why are you just raising the jurisdictional limit to $75,000 but not $100,000. For SMEs, there are a lot of monetary disputes, and many of them would turn to the SCT. The current limit is $50,000. It's not enough, and some parties would only file claims for $49,000. Costs the rise to $75,000 would be welcome, but it would be even better to raise it to $100,000 because businesses are reluctant to hire lawyers because they charge hefty fees. And at the same time, the lawyers might not want to take up these cases because the claims are so small. So there's a lack of efficiency. So of course you can come to the Electrical Establishment Committee or Finance Committee for more funding, but as Mr. Dennis Clark said, there is a lack of manpower. There are 36 vacancies for DC judges and 7 for High Court judges. So even if you offer the money, no one would want to come. But as you know, judges are not in it for the money. For lawyers in private practice, they can become millionaires, billionaires. I'm sure that people who want to become judges want to defend the judicial independence of Hong Kong and to serve justice. Money is the last thing they are asking for. But the reality is that there is not enough manpower. 2 days ago, at the AJLS panel, we talked about introducing more practicing solicitors, and the Law Society proposes a new approach, and PCLL is required on top of a law degree before you can become a practicing solicitor. So there is some controversy. For the Bar Association and universities offering PCLL programs, they are stopping the Law Society from introducing this new recruitment mechanism. And Mr. Chow from HKU said that we have about 1,200 law graduates applying for PCLL every year. He asked whether there are enough jobs in the market. If not, what's the point of offering so many places? So this coming from a so-called academic. So for universities offering PCLL programs, are they controlling the number of places? So does it is it leading to a lack of trainees and practicing solicitors? And the Chief Secretary and SFTB should review the situation. We have enough students, but we don't have enough school places. So this is a structural problem. If we have enough school places, if we have 1,200 instead of 700, we would have more graduates, and more of them can become trainees. And with enough practicing experience, they can join the judiciary, and you might be able to fill those vacancies. And you can fill those 36 vacancies soon. So we are looking at a structural problem, but not money. You have the students, but you don't have enough program places. So at the end, you won't have enough people serving in the legal profession. Mr. Dennis Kwok talked about manpower shortage, and this prompted me to consider the shortage of program places. We are looking at the DCO and SCT ordinance. I think we must review the entire judiciary or judicial system, and I will speak again during the committee stage. Mr. Wuchiwai.
President, we think the two resolutions are going in the right direction. This is the view of the Democratic Party, because you're lowering legal fees so members of the public can gain better access to justice. This impresses me. At the DC, as mentioned by members, we lack 36 judges. Now we are raising the jurisdictional limit to $3 million, a jump of 300%. Remember, if you are seeking more than 1 million, you have to go to the High Court, and the fees are higher. However, at the SCT, as Mr. Felix Chung said, it handles a lot of SME and micro enterprises claims, and also small debts, and also disputes between neighbors and contractual disputes. They all involve small amounts. Over the past 19 years, we come to know that this amount is not able to take care of claims. When people face disputes, as Mr. Felix Chung said, if I cannot claim 70,000, I would go for something below 50,000 in order to save legal fees. And I will ask a very simple question. I have read your script, Mr. CS4A. You pointed out that the administration considered 3 factors. 1, so that the public can gain access to justice. Now, if it is enhanced even further, then isn't it going to be even easier for the public to gain access to justice? That is, people have to consider whether the legal fees are proportionate. If it is not, then it would be up to the SCT to handle it, because it should be able to allow the public access to justice without paying legal fees. The second factor is the operational need of the SCT and how it will be affected. Well, you will have to compare this with the actual demand. You can see that there are these claims, and over a period of 20 years, please look at the rise in claims, and you will know that it is too much to raise it to 100,000. I know some water seepage cases, and the maintenance and repair part would fetch 100% more in expenses. And I'm talking about 2003, and if you look at now, the increase would have been greater. To tackle water seepage, you need to engage a notary, and you will have to pay for it. And if the case goes to court, you will have to engage experts to write reports. All that would bring the bill to beyond 50,000 or even 75,000. Look at other contractual disputes. particularly with regard to fitness centers, you will see that the claims are not of small amounts. Therefore, you have to be realistic in considering the amount allowed. And you talked about the impact on the operation of the SCT. Actually, at the end of last year, you already did your sums, and you have already anticipated that impact if it is raised to 75,000. If that's the case, are you saying that if it is further raised to 100,000, you mean there will be such a big difference in the impact done to the SCT? If that's the case, it implies that without that bigger jump, a lot of members of the public would be kept out of the door of the SCT. Moreover, if the judiciary cannot cope with the demand in the short term, it would just mean that people have to wait longer for cases to be heard. And even so, I would still be able to gain access to justice. And that would still be better than keeping me out of the door altogether. Members of the public should be able to gain access to justice, and it should be enhanced. And I believe that is the spirit behind this amendment. I understand when you decided on 75,000, you had taken it up with the Law Society, the AGLS panel, and also the Bar Association, and they have all agreed. But does it mean that they would object if you raise it to 100,000? I don't think so. As Mr. Felix Chung said, to many law firms, these are really peanut cases. And if you look at another figure, you will understand better. Last year, we increased the fees for duty lawyers under the legal aid scheme. And in this table, I can see that at District Court, the engagement fee is up to above 10,000. We are talking about legal fees under the legal aid system. Well, that is the 1 day's fees for appearance in court. But if you are talking about extra preparatory work, the legal fees would be higher. And you can imagine, even if you raise it to $100,000 for SCT, and if you juxtapose that with this legal aid table, you will see that the legal fees allowed are not proportional. I therefore hope members will really think deep about this. This is not whether we support it or otherwise. We are just talking about whether the amount should be enhanced to 100,000. That is the jurisdictional limit of SCT. Shouldn't it be enhanced from 75,000 to 100,000, just like Mr. James TO is proposing, and that is a 100% jump? At the District Court, you are raising it by 300,000. And I must urge you to think about this. In our daily work, we have seen numerous such cases, and we deliberately suppress the claim amount so that you can go to SCT where there is no legal representation, and so that you can still gain some access to justice. I would still ask members to think about my viewpoint. That is, if I can be listed, I would want to wait. And I hope in the next year or so, I hope the administration will come up with proposals to increase human resources for the judiciary and also court facilities in order to take care of the backlog of cases. Let us not just say we will review after 2 years, and then for this to come back to the LegCo for a new resolution to be passed. If we can pass Mr. James TO's amendment today, the administrative issues would be such that the administration would have to add manpower resources and facilities. Failing that, we might have to go through another rather protracted consultation exercise, and there will be 2 steps. You will have to come back for funding, support for creation of posts, and then you can bring another resolution for endorsement of a larger claim amount. The process would not help you achieve your work objective of enhancing the public's access to justice. I hope you will consider from this angle. I'd rather the public should be able to consider what they can afford to when they want to make a claim. I hope the SCT can take care of claims up to 100,000, so you can meet the demand of the public in handling small claim disputes, so you can solve the problem. I speak in support of Mr. James TO's amendment, and I hope the administration will really think seriously about it, and I hope our pro-establishment colleagues can consider accepting Mr. TO's amendment. Thank you.
Does any other member wish to speak? Chief Secretary for Administration, you may now respond to Mr. James TO's amending motion. Mr. President, I thank 8 members for speaking on the subject. I want to emphasize that increasing the civil jurisdictional limit of the DC and the SCT has come by as a result of careful consideration of all factors by the judiciary, and having considered the views of the stakeholders, the proposal would rationalize the distribution of caseload among the Court of First Instance, District Court, and Small Claims Tribunal, so that the resources of the judiciary could be put to optimal use. The proposal would also help lower legal fees so that the public can access justice without barrier. Increasing the jurisdictional limit of the Small Claims Tribunal to $75,000 would allow more litigants to, through the tribunal, resolve civil disputes with lower amounts involved in a more expeditious manner. As for the civil jurisdictional limits of the Small Claims Tribunal, as I mentioned in the opening remarks, any amendment would have certain impact on the operation of the Small Claims Tribunal. The court users in using the service, the judiciary therefore must go through very detailed and objective analysis on the impact and fully consulted the stakeholders before introducing new civil jurisdictional limit. This is only reasonable and just. The judiciary has also been adjusting the civil jurisdictional limit based on the same principle. When we discussed with the subcommittee on the proposal, together with the judiciary, we explained to members of the subcommittee and Mr. James TO that the judiciary is proposing to increase the limit to $75,000 only after the above-mentioned analysis and the procedure. And in fact, during the consultation period, we have sought the general support of the Hong Kong Bar Association, Law Society of Hong Kong, and the Panel on Administration of Justice and Legal Services. And having considered the government and the judiciary's explanation, the subcommittee also supports increasing the jurisdictional limit to $75,000. The government or the judiciary cannot really support Mr. James TO's amendment without having conducted any impact assessment and the relevant preparation work and consultation with stakeholders. We therefore oppose Mr. James To's amendment. We understand that Mr. James To, in putting forward his amendment, may have drawn reference from some information about caseload of the District Court and Small Claims Tribunal earlier provided by the judiciary, as well as open data to decide whether the Small Claims Tribunal has the capacity to deal with the proposed $100,000 jurisdictional limit. I must emphasize that in assessing the impact on the operation of the Small Claims Tribunal and the service capacity, apart from analyzing the caseload data, we also need to consider the important factors.
First of all, after raising the level of jurisdiction, the tribunals may have to face the so-called suppressed demand. In other words, many litigants may only make a choice when it involves such a low level of cost when you put in a claim at a tribunal. And then, as a result of the raised amount of claim permitted, the complexity may be enhanced. And thirdly, in fact, the fact that tribunals will not allow legal representatives for the litigants to be present at the hearings as a result of this change that may have an impact on the operation of the tribunals. And in fact, Mr. James To's proposal cannot take care of the concerns that I have listed. And we have noted the concern of Mr. James To. That's the case of the judiciary. The judiciary has already promised that after raising the limit to $75,000 in 2 years' time, they will look at the volume of cases involved, and in the light of the actual operation, they will check if there is room and justification for further enhancing the limit of the jurisdiction. As to whether there should be more frequent review of such measures, the judiciary has already said that after the current exercise, they will pay closer attention to the change in the volume of civil cases as well as the impact on the operation. They will also look at the economic indicators and their changes as well as the views of the stakeholders, and in good time they will carry out another review. I would like to urge members to support my two proposed motions and veto the proposed amendments raised by Mr. James To, so that we can raise the limit of the civil jurisdiction and allow the jurisdiction to be extended from $50,000 to $75,000, so that more litigants can seek to have the justice addressed.
This council now first votes on the CS first motion. I put a question to you. The first motion moved by the CS be passed. Mr. Holden, Child Claims Division, the bell will ring for 5 minutes.
開始表決。
Will members please proceed to vote?
林健鋒議員，你是否想投？
Mr. Jeffrey Lam, are you going to vote? Please check your votes. If there are no questions, voting now ends. I display the results. 62 present, 61 for. The question is agreed by majority of the members present. I declare the motion passed. This council now deals with the CS's second motion and Mr. James TO's amending motion. CS, your second motion, please. President, I thank members for endorsing the first motion. I move the second motion as set out in the appendix to the script regarding the increase from 50,000 to 75,000 for the SCT. Mr. James TO, you may move the amending motion to amend the CS's second motion. President, I move that my amending motion as set out in the appendix to the script be passed, and that is to increase the jurisdictional limit of the SCT from $50,000 to $75,000. I propose the question to you that the amending motion moved by Mr. TO to amend CS's second motion be passed. Mr. James TO claims a division. The bell will ring for 5 minutes.
開始表決。
Please proceed to vote.
請各位
Please check your votes. If there are no questions, voting now ends. I display the results. FC, 33 present, 6 for, 18 against. GC, 28 present, 12 for, 10 against. The question is not agreed by majority of the members present. Declare the amending motion negatived. I now call upon the CS to reply. Then the debate will come to a close. CS. President, I understand Mr. To's amendment. I know where he's coming from. He hopes that more litigants will be able to get access to justice. But I hope that members will understand that the government and the judiciary do have cogent reason not to accept Mr. To's amending motion. The judiciary said that as a result of the implementation of the SCT's jurisdiction of $75,000, it will monitor the statistics over the next 2 years, and also the implications to see whether there would be any justification to increase the jurisdictional limit. I urge members to support my motion that the SCT's jurisdiction be increased from $50,000 to $75,000. I now put a question to you that the second motion moved by the CS be passed. With those in favor, please raise the hands. Those against? I think the question is agreed by majority of the members present. I declare the motion passed. The Secretary for Development and the Secretary